This will be our last look at what happened to Elk Horn Coal Corporation and the Consolidation Coal Company during the 1950s. While this case is annotated by Justia Law, we can get a glimpse as to how the fight over mineral rights and their true value, and not the value of the entire land itself, ended with the construction of Dewey Lake and the Jenny Wiley State Park. Come along with us as we walk through the last case for both companies. All aboard the Kentucky-Tennessee Living Time Machine. Please fasten your seatbelts and keep your arms and legs inside of the vehicle at all times. But to get going, we need your help. We still need to fire up that time machine to transport us. Please help us by clicking on the like, subscribe, and bell notification buttons down below. Not only does this fire up the time machine for our flight back in time, but it convinces the YouTube algorithm that we need a bigger vehicle to reach more people who love history as much as you do. Now, back to our story. The final case of Elk Horn Coal Corporation. The Elk Horn Coal Corporation lost its case concerning land in Floyd County in a district court. The land was condemned because there was no access for rail or truck to reach where the coal was located. Floyd County wanted to turn the land into a public use area, so Elk Horn Coal Corporation filed a suit to prevent the land from being condemned. The district court ruled against the corporation, and so the suit, the Elk Horn Coal Corporation versus the United States of America, Sixth Circuit Court of Appeals, 1953, began. The case can now be found under the U.S. Court of Appeals for the 6th District Court, 215 F 2D 917, 6th Circuit, 1955. The date of the final judgment was handed down on February 15, 1955. Representing the appellants of the case were J. W. Howard of Prestonsburg, Kentucky, and J. Henry Francis, Jr. of Charleston, West Virginia. The representatives for the appellants of the case were Perry W. Morton, Roger P. Marquez, John C. Harrington, and Reginald W. Barnes of Washington, D.C., Edwin R. Denny, Hitt C. Ellswick of Lexington, Kentucky. The judges in the case were Simmons, Chief Judge, and Allen and Martin, Circuit Judges. The case is an appeal action brought by the United States against the Elk Horn Coal Corporation. It involves only the mineral rights concerning 327.39 acres of land in a mountain section of Kentucky, along with the severance value of the mineral interest in the remaining lands owned by the appellants. The District Court ruling. Upon the conclusion of all the evidence provided to the court by both government and the appellants, the District Court ruled as follows: that an award of, quote, $15 per acre as the fair market value of the mineral interest taken and denied all claims for severance damages to the mineral interest owned by the appellants in the remainder of the tracts not taken, unquote. The district judge gave a comprehensive statement concerning his findings in the case and points of law that were used to draw his conclusions. According to Justia Law, this was his ruling. Quote, the court stressed the fact that the C&O Railroad Company in 1944, after making an investigation of the potential value of the coal lands, apparently abandoned forever any idea of running a railroad up there at a cost of several $1,000,000 to haul out the coal in controversy. Directing attention to the fact that the government's proof had shown the mineral rights taken to be worth $10 an acre or less, the judge stated that the appellants had wholly failed to establish the value of the coal on a fair market basis as higher than $15 per acre. He asserted that the sales of other property in the vicinity and the potential value of the mineral rights had been taken into consideration in reaching his conclusion. Applying the same principles upon which its evaluation of the mineral rights of the land mentioned had been reached, the court held that the coal underlying the severed lands had not been proven to be of sufficient consequence to cause a railroad to be built to get the coal out, and that the lands could not be mined economically by the use of trucks so as to give the minerals extracted from the severed lands any commercial value. Therefore, no severance damages were allowed, unquote. So what does all of this mean? Basically, Elk Horn Coal Corporation was trying to state that the value of the coal per ton was the same monetary value no matter where it was found. However, because of the lack of access to the 327.39 acres of land, this should not cause the value of that coal to drop. But the judge did not agree with this assessment, as it is stated that there was not enough coal under this land to make a railway or a truck access. Because of this, there was to be no difference one way or the other way about the coal's value. And for this reason, Elk Horn Coal Corporation should not receive any damages. The U.S. Court of Appeals for the 6th District Court upheld the ruling of the District Court as it could not find enough substantial evidence to vacate the order. While there were errors concerning the value of the mineral rights taken and the value, if any, in the severed mineral rights, it was not enough to rule against the District Court. Floyd County wanted to make a lake resort from the 1,100 acres of the land inside of its borders. The court basically ruled against Consolidation Coal Company and the Elk Horn Coal Corporation, and Dewey Lake State Park was then formed on January 1st, 1954. The park was then renamed to the Jenny Wiley State Resort Park in the 1950s after a pioneer woman named Virginia Jenny Wiley. To see more about who she was, please watch our series about Jenny Wiley. With the construction and opening of May Lodge in 1962, the resort became a part of the Kentucky State Park system. So, what happens after this? Well, because of the constant bankruptcies and the filing of the U.S. government against the Elk Horn Coal Corporation and the Consolidation Coal Company, they began selling off their assets in 1930. This was completed in 1956 with the final sale going to Bethlehem Steel, who mined coal under Beth Elkhorn Coal Corporation. In the 1980s, Beth Elkhorn Coal Corporation closed its doors in eastern Kentucky. While there is still some mining that is going on in the area today, through different acts and bills passed of Congress, and the green movement in the mining industry is nothing like it used to be during its heyday. Long gone are the tens of thousands of people who occupy the cities of Jenkins, Neon, Whitesburg, Wheelwright, and others. And one has to wonder if the downfall of the Consolidation Coal Company and the Elk Horn Coal Corporation did not happen because of the actions of one of its leaders, Clarence W. Watson, and others who would later replace him. Or if the coal industry was doomed from the beginning, as other methods of energy would be discovered, or possibly both reasons combined made the perfect storm. Whatever the reason, the Appalachian people have been abandoned, as no new industry or factories have come into the area. As one of the Appalachian Mountains daughters, I sure hope that something breaks for our people so that we can have a better future for our children. Thank you. Kentucky Tennessee Living would like to thank you for watching our video series on the scandals of the Consolidation Coal Company. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notice when we upload a new video, be sure to subscribe and click the bell notification button. We thank you for continuing to support Kentucky Tennessee Living as we are discovering the mysteries in Appalachian history.